Okay, we're going to go ahead and get started. So hi everyone, my name is Megan Bruce and I'm the Online Communications Manager here at Juvenile Law Center. Thank you for joining us for today's webinar, Education for Kids in Care, What Judges and Attorneys Need to Know. This webinar is co-hosted by Juvenile Law Center and Education Law Center of Pennsylvania. And in case you're not familiar with these organizations, Juvenile Law Center is a nonprofit public interest law firm that works nationally to enforce and promote the rights and well-being of youth in the child welfare and justice systems. Our strategies include litigation, appellate advocacy, and submission of amicus briefs, policy reform, public education, trainings like these, and strategic communications. An Education Law Center works to make good public education a reality for Pennsylvania's most vulnerable children through litigation, training, information sharing, advocating for new laws and policies, and working with the media and other organizations across the state. Before we get started, I just want to run through a few technical issues. If you're participating by phone today, your line will be muted during the entire webinar. So if you have any questions during the webinar, you can type those into the questions box, and that will appear in your GoToWebinar control panel, which is that long rectangle-looking thing on the right side of your screen. There's a little orange arrow at the top of that rectangle, which you can click to expand and collapse the control panel. We will try to save some time at the end of today's webinar to answer your questions, but please note we may just have a limited amount of time and we might not be able to get to all the questions today. Also note that all webinar materials, including the PowerPoint and the publications that we'll be referencing, will be sent to you in a follow-up email tomorrow. We're also recording this webinar and we'll include that link to the recording in that email. And the materials will also be posted on our website at www.jlc.org. Okay, and now I'd like to turn it over to today's presenters. Kate Burdick is an Equal Justice Works Fellow sponsored by Greenberg Traurig here at Juvenile Law Center, and Maura McInerney is the Senior Staff Attorney at Education Law Center. So I will let you guys take it away.
Thanks so much, Megan. This is Maura McInerney from the Education Law Center. Thank you all for joining us. We really, really appreciate your time today. So we just wanted to get started giving you an overview of what we're going to talk about today. First, just to make a few comments about why this is so important. Sometimes education is really an overlooked area with respect to kids in the dependency system, and yet we know that these kids are really in educational crisis. For example, 50% of them do not graduate from high school at all, and only 1/3 will graduate on time. They score far below their peers on standardized testing. They're more likely to repeat a grade. They're more likely to be out of school. So these are critical issues for kids because, as we all know, education is really linked to life outcomes and life stability. We know that 1 out of 8 adults who are in prison, you're 8 times more likely to be incarcerated if you don't have a high school diploma. You're far more likely, 50% more likely to be homeless. These are huge issues that plague these children for the rest of their lives. So it's really, really critical that when we're looking at educational outcomes, that we're thinking of it as being life outcomes. And it's also linked to greater percentages, greater likelihood of permanency for children in the dependency system. So we're talking today about educational advocacy in the courtroom, taking the Juvenile Court Rules that were enacted in July of 2011 and talking about how we can do advocacy in the courtroom to improve educational outcomes for this vulnerable cohort. So we want to focus really on 5 issues, 5 questions we should be asking in the courtroom. Are children enrolled and attending school, and do they have school stability? We'll talk a lot about that today. Are they in the right school placement, a place where they are going to be able to advance, make promotion, graduate from school? Do they have an active, involved decision maker, or do they need an appointment of an educational decision maker? Are they making academic progress on track to graduate, or do they need interventions? And has the youth engaged in real graduation transition planning? We know from national studies that children in the dependency system that only 3% actually graduate from post-secondary, even though and it's only between 13 and 17% that are involved in any post-secondary education. So we want to really look at all of these issues in detail.
We're going to go ahead and have our first poll of the day. I apologize for that reverberation. So we would like to know, how often do judges in your county ask questions about education at court hearings? I apologize if others are hearing the sort of backlash that I'm getting there. But in the meantime, go ahead and please select an answer.
So how often do judges in your county ask questions about education at court hearings? We'll give you a few seconds to fill out the poll.
All right, well, we see it's pretty well split. I'm glad to see that never has gotten 0%. We have 32% saying always, judges are always asking questions about education at the court hearings. That's great to hear. And as we're going to talk about next, this is something that really should be addressed at every single hearing. So we're glad to see that we're making progress towards that in your county. We're going to go back to the presentation now. So, whoops, went too far. So, in 2011, as Maura mentioned, the Pennsylvania Supreme Court approved changes to the Juvenile Court Rules that really did focus on addressing education, health, and disability needs of the child at every stage of the adjudicatory process. And the reason for this is that education really shouldn't be an afterthought. It's crucially important to the child's well-being. In fact, when the Pennsylvania Supreme Court approved those rules, they mentioned in their report explaining the changes that educational, healthcare, and disability needs of juveniles or children in the system must be met in order to ensure their welfare, health, and safety. The court's role in addressing these needs is not merely a matter of best practice, but rather an essential component to ensuring the fundamental needs of juveniles or children under its supervision are addressed. So, although we of course recognize that courts have very busy dockets and it's difficult to get to every issue, this really needs to be something that's addressed early on, and the Pennsylvania Supreme Court even recognized this, saying, again in their report, that it should be addressed at every stage of the proceedings, including as early as the detention and shelter care hearing, inquiring about any special needs of the juvenile and child, and then putting that information into their court order. And we're going to talk more about what should be looked into in terms of education in just a moment, but as an overview, again, making sure the child is staying in the same school when in his or her best interest, ensuring they're on track to graduate, that they have an authorized decision maker for their educational needs, and that they have a detailed transition plan. So now that we know so many judges are asking questions about education at the hearings, we have another poll for you where we would like to know what they're usually asking about. So you can check all that apply here. Are judges asking, is the child attending school, or are there truancy issues? Are they asking about any special education issues? School placement, which would include whether they have school stability, if they're in a residential facility, whether they're going to the on-ground school, whether an educational decision maker should be appointed for the child, and other information about their grades, credit, and progress towards graduation. So we'll give you a minute to think about which of those issues our judges usually ask me about when they do bring up education at court. Great, okay, so attendance and truancy seems to be the biggest category here, along with grades, credits, and progress towards graduation. Then special ed and school placement are being addressed about 50% of the time, and whether or not the child needs an educational decision maker, a little less than a third of the time. So that's great to hear because if we go back to the presentation, the thing we want to focus on here is the fact that judges really shouldn't just be saying, is the child in school? That's not enough. Unfortunately, the child may be attending school and still not having their needs met. It may not be an appropriate educational placement. They may need to be evaluated for special education, or even if they have already been identified as being eligible for special education, they may need a different individualized education program or have that be updated. They may not have an adult who's authorized to make decisions regarding their education. And they may not be making progress towards graduation. So just making sure the child is actually attending school is not enough. The good news is, to help you navigate this process, whether you're a judge or an attorney or a caseworker or another child-serving professional, we have a number of tools that you're going to be provided tomorrow when you get the email that follows up on this webinar. One of them is a one-page checklist for judges to go through in court to make sure they are addressing more than just whether or not the child is in school. And we have, along with that, a more detailed document which is called the 5 Keys to Implementing the Juvenile Court Rules Regarding Education and Health, that gives you specific language for the court order and for the findings related to education on many of the areas that you do need to be addressing. So be sure to look out for those tomorrow. We'll also be highlighting some of that as we go along in today's presentation. For the attorneys who are on this call, we want to emphasize that you really need to prepare for court and know what's going on with your client educationally. It's not enough to just go on the report of the caseworker or someone else that you're working with that everything's fine with the child's education. You need to be speaking to your client and also, if possible, requesting the records, the school records, which Maura will talk about more in a second, an easier way to get those now, but to really investigate what's happening with the child's schooling. How are they going to school? How often have they had to change schools if their living placement has changed? And what type of school are they attending? Are they in the local public school in their district? Or are they in, for example, a cyber school or an alternative education for disruptive youth program? Are they going to the on-ground school if they're in a residential setting? What else might they need? If they're not getting good grades, what is the problem? And are they getting credits and otherwise making progress? So we have for you attorneys a pre-court educational checklist that we will be sending out also tomorrow that you can use to help you prepare for court, so that when judges ask you these questions in the courtroom, you're prepared and you're able to advocate effectively for your client, or that you can raise the issues yourself if the judge does not bring it up. And you can also use the court hearing to get answers to questions that you don't know the answer to off the top of your, through your research, I mean.
So one of the things we wanted to mention is that education records are now more easily obtained. In January 2013, there was a significant new amendment to the Family Education Rights and Privacy Act, whereby representatives of child welfare agencies can obtain education records without first getting consent from the parents or without a court order for children who are in out-of-home placement. So this is really important because it facilitates obtaining those records so that the caseworker can look at those. In addition, under the amendment, child welfare workers are permitted to redisclose those records to anyone involved in meeting a child's educational needs. So that's an important exception to the general prohibition that you can't redisclose education records. So in some counties, we now have child welfare agencies and private providers receiving education records electronically. To the extent that counties can do that, that's really, really helpful so that folks can see the education records as soon as possible. Those education records would include attendance, grades, progress reports, an IEP if the child's in special ed, 504 plan, and the disciplinary record. So the first issue we wanted to cover is ensuring that the child is enrolled in and attending school. We know from research that children are often not going to school immediately. They have delays in between going from one school to another. So it's important to really ensure the kids are attending school. So the in-court questions that we want to ask are, is the child currently enrolled in and attending school, and how many days have been missed? So just in general, when we talk about truancy, the trigger for that is 6 unexcused absences, so 6 days out of school. So that's important for folks to think about. And those are unexcused absences. A child's absence is excused if they're in court, if they're attending conferences, etc. So we want to look at whether that child is missing days. We know from a recent Child Policy Lab report that children miss on average 25 days of school while in dependent care. That's a lot of weeks of school. So we need to be really looking at that. If the child has a history of truancy, which many children often do coming into the dependency system, we need to make sure that there's a truancy elimination plan, that truancy issue is being addressed by the school. So just in broad strokes to remind people, children must be enrolled within 5 days of submission of 4 enrollment documents. And that includes a record of the age of the child, record of immunizations. It also includes a residency. If the child's in out-of-home placement, that's just on letterhead. And in addition, there has to be an Act 26 or parent registration form that talks about the child's disciplinary record. That's it. Once you submit those 4 documents, the child has to be enrolled under the school code within 5 days. That includes children going to a cyber charter school or whatever charter school they're going to as well. All of those are public schools. And a child has a right to attend school up until age 21 or when they graduate from high school. So that's really critical. We have a lot of kids who may be overaged, undercredited. Those kids have a legal entitlement to be attending school even if they don't have sufficient credits to graduate, even if they have a GED. On the truancy side, we must make sure that the child welfare agency is addressing attendance and that they're working with the school district, the local education agency to do that. And if a child is truant, we have to be looking at whether they have a truancy elimination plan and that we're trying to address the root causes of that truancy. Just 2 minor points that we wanted to make on truancy, and I think this is true in most of the counties. It's usually not the sole reason to place a child in out-of-home placement. In addition, truancy should not be a reason to send a child to an on-ground school or residential setting. That does not address the underlying causes of truancy. That child is likely to lose ground while at the on-ground school, and when they go back to the regular school setting, they're likely to continue to be truant.
All right, and that brings us to our next topic, which is the right to school stability. And just so we're clear, when we're talking about school stability, we mean that the child has the right to remain in the same school, even if their living placement changes. We're going to talk more about that. So what types of questions should either the judge be asking in court or the attorney raising? Will the child who has to change living placements be placed in the same school attendance area whenever possible? Even if you have to change living placements, we hope that that child is going to be in the same district or catchment area so that the issue of school stability is a non-issue and we don't even have to get into whether or not they're going to change schools because they're still in the same area. But unfortunately, we know that many times our living placement options are limited and that is not a possibility, in which case we need to look at, is the child able to stay in the same school despite the fact that they've moved away? There is a presumption under the law in favor of school stability. So if the child is not going to stay in the same school, the court really needs to investigate why. Is there something about that program that's not meeting their needs? We're going to talk more specifically about what factors to consider there, but that there should be a conversation about that in relationship as well to the child's overall goal and plan under the dependency laws. And of course, if the child is able to remain in the same school, we need to make sure that that happens seamlessly and that transportation is provided to meet the child's needs. Hold on, changing slides. Okay, so when we're talking about school stability, there's two relevant laws here. The first you may have heard of, the McKinney-Vento Homeless Assistance Act, provides really robust protections to youth who are experiencing homelessness. We'll define that in a moment. But that includes the right to remain in the school of origin, which is defined under the law as either the school the student attended when they were last permanently housed, or the school in which the student was last enrolled. So for some students, they may have more than one option when considering school stability. If it is in the child's best interest to remain in the same school, or in their same school of origin, I should say, the school district needs to provide transportation to make that happen. Under McKinney-Vento, there's also a detailed appeals process whereby if the school district does not allow the child to remain in the school of origin, they need to explain that in writing, and this child has the right to remain in the school that they would like to attend while the dispute is being resolved. And of course, if it's not in the child's best interest to remain in the same school, they actually have the right to be immediately enrolled in a new school without any documents. So those four documents that Maura just went over for regular enrollment, immunizations, residency, that doesn't apply to children who are eligible under McKinney-Vento. So they need to get into their new school ASAP. And as well, youth who are eligible under McKinney-Vento have the right to comparable services and equal access the same way they would if they were not experiencing homelessness. And we really want to underscore that this act provides a lot of protections and should not be overlooked simply because you think that maybe the child doesn't qualify if they're in care. They have the right to have school uniforms, supplies, a free or reduced school lunch, and schools may even have extra funds available to help them with things like test fees or tutoring, other things that would help them with school success. There's a liaison in every school district to assist youth who qualify under this act, so it's really important to think about whether this applies. And who is considered homeless under this act? So youth who are in shelters and places that we more can typically think of when we are thinking of someone who might qualify as being, quote, homeless, but also unaccompanied youth who are living on their own and not currently in the custody of a parent or guardian. This would include youth who have run away from home, been thrown out of their home, or otherwise abandoned or separated from their parents for any reason. It also includes youth who are awaiting foster care placement. That is the terminology from the federal law, and the Pennsylvania Department of Education has defined that for us in our state in the Basic Education Circular on the Education for Homeless Youth, which you can find on PDE's website. And they define awaiting foster care placement. It's typically going to be a short-term placement lasting 30 days. However, the BEC does allow for individual circumstances there to be someone who would qualify under McKinney-Vento even if their placement is lasting longer than 30 days. But usually we're talking about emergency placements, evaluation or diagnostic centers, or respite care. So don't forget about McKinney-Vento. But in addition, we have another, let's see here, federal law that provides for school stability for youth who are involved in the dependency system. This is the Fostering Connections Act of 2008. And this is a child welfare law that requires for the case plan to include assurances that the local children and youth agency has coordinated with the local education agency, which is typically the school district, to ensure the child remains in the school in which he was enrolled at the time of placement, unless remaining in the same school is not in the best interest of the child, in which case the child has to be immediately enrolled in a new school. In determining whether or not the child, it's in their best interest to go to a new school, there are many factors to consider. And we have included in our materials a best interest determination form. It's usually something that the agency would be filling out, but the court can certainly ask those questions and review the decision and make a determination as well regarding best interests. And we'll talk about those factors a little more in a second. wanted to give you some sample language. Again, in the document we are including tomorrow, we have even more detailed findings and order language that you can use regarding school stability, but we wanted to highlight some here, in particular when the court finds that it's in the child's best interest to remain in the same school. Before we finish up this topic, we have one other poll for you here. So does school stability apply to children who are in congregate care? So children who are in group homes or a residential treatment facility, for example, do they have the right to school stability? Just select one answer. All right. Okay, great. Glad to see that the overwhelming majority of you think yes, the child does have the right to school stability even if they're in congregate care. This was a little bit of a trick question because oftentimes when thinking about whether or not something is in the best interest of the child to attend the same school or not, you might think, well, the placement is too far away for this to be in their best interest, or it really is their best interest to be going to a different type of school. So, and that is certainly something that can come into play when you're weighing the factors, but as a rule, school stability does apply to children in congregate care, and we wanted to put this in a poll specifically because it's often not thought about for children who are in those settings. The best interest factors include things like the child's preference, safety, where any siblings are going to school, what time of year it is, and the commute could be one of the factors that is considered, but it's not the only one. And particularly, let's say we have an older youth who is getting ready to graduate, they're in their senior year and it's the final semester, it would likely be in their best interest to continue attending the same school even if the commute is very lengthy to their new living placement in a congregate care setting. All right, back to the presentation.
So we wanted to talk about children and whether they're in an appropriate school setting. We really feel that this is an important issue to highlight because disproportionately children in the dependency system are often placed in disciplinary settings, they're placed in restrictive environments, and sometimes they're treated in a different manner than other children, than their non-dependent peers. So we just wanted to walk through and highlight a few different school settings so that we sort of are asking questions that are appropriate to determining whether it's a good setting for the child. So I think really importantly we want to say, is the child in a full-time regular public school? So are they attending school, regular school district, and are they getting a full day of instruction? So that would be 27 hours, for example, a week that they're attending school. And are they in a regular school setting, meaning that they're not in a disciplinary setting, they're not in alternative education for disruptive youth. So, so full-time instruction is important. If you look at an on-ground school in a residential setting, just wanted to highlight that that is in many ways unregulated. It is monitored by the Special Education Bureau of the Pennsylvania Department of Education, but in general, those are private academic schools. They're treated in the same manner as a prep school. Their curriculum can be entirely different than a public school. They can, you know, operate in very, very different ways with different teachers and that kind of thing. So it's very, very important to recognize that those are really treated differently. We at the Education Law Center had done a one-year study looking at congregate care placements and interviewing youth, doing in-depth reviews and doing a lot of surveys and questionnaires. And we have a report that's available on our website, but in general it talked about the fact that in many instances children are given worksheets that are far below their grade level, etc. So we invite you to look at that. So cyber charter schools, those are public schools. Those are authorized by the Pennsylvania Department of Education. There are 16 different cyber charter schools. In general, over the last 5 years, not one of them has made adequate yearly progress. It's a huge issue for kids who are educationally at risk, that sometimes that is not an appropriate placement for them. It's something to think about. Homebound instruction, that is only for instances where where it's medically necessary that the child be educated at home. That is 5 hours per week of instruction. Those are intended to be very, very short-term placements for children for whom it's medically necessary. Want to make sure that that is not overused. We've had cases in our office where kids have had a particular type of disability but were able to attend school, but instead they're getting homebound instruction, really undermines any kind of academic success for those children. We want to look at whether the child is in the least restrictive environment for kids with disabilities, that they're being educated with their non-disabled peers to the extent possible. Then we want to look at school discipline settings. Alternative education for disruptive youth under the school code is limited hours, 20 hours per week, only in core subjects, no electives. They should be offered 2.5 hours of counseling in those settings. Those are intended to be short-term. There's a basic education circular on alternative education for disruptive youth. Invite you to look at that. Those kids are supposed to be evaluated every semester to determine whether they should return to the regular school setting. So it's very limited hours. It's really something important to look at. Many of those settings, those programs are actually privately provided, not through public schools. So they look very, very different across the state. We also have cyber programs in a district, where districts are now running their own cyber programs within their school. It's important to ask about that as well. That is not a punitive setting. That's not where kids should go. We also want to look at whether kids are being suspended or expelled. And in general, kids in dependent care are suspended and expelled at higher rates, and it often disrupts their living placement. So another poll here: how often do students in congregate care placement attend an on-ground school? If folks could answer that question. Okay. Okay. So how often do students and congregate care settings attend an on-ground school? Majority, 67%, said in most cases. 26% said sometimes. So this is really a concerning statistic, because we want to go on to the next slide to talk about the fact that kids in congregate care settings have a legal entitlement to attend the local public school. This is under 24 PA Code 131306. So we want to, that says a school district in which a children's institution is located must allow that child to attend school, the public schools within the district. And a children's institution is defined under the code, under regulations, as a group home, licensed shelter, or other institution for the care training of children or adolescents. It includes a residential treatment facility. It includes a rehab center. It includes all of those placements. And the presumption under the basic education circular that talks about kids in the education of children in non-educational settings says that the presumption is that these students will receive their education in the regular public school unless the parent or guardian and appropriate public officials determine that the educational placement is not proper for that child. And that, again, is limited. So this is a host school district cannot refuse to enroll a student unless there is a court order directing that the child be educated on site. And that's something we really ask judges to think about, because as we know, the educational outcomes of those children are often very, very poor coming from on-ground schools. So we want to, so the only exceptions are a court order that requires that the child be educated on site, or a current individual education, an IEP or NORA, or a 504 agreement that requires a different placement. So it may say that the child has to go to an improved private school or has to be in a different placement such as that. In addition, if a child is currently expelled for a weapons offense, they can be placed in alternative education for disruptive youth. But other than that, the child should be attending the regular local public school. If a student is in an interim alternative educational setting, they have to be placed in accordance with the IDEA. So we have some recommended language that we recommend that you consider to incorporate into the orders that will squarely address that the child should attend the local public school and is not required to be educated on grounds.
And it's really important to have that language because even though the presumption under the law is that the child will go to the local public school, because there's often confusion, as evidenced by the responses to the poll, having language that clearly states that the child shall attend the local public school or that the IEP team for the child should determine the placement can clarify things, move them along, help prevent confusion and delay in getting the child into that appropriate local public school setting.
And importantly, if a child has special education needs, if they've been deemed eligible for special education, it's the IEP team that should meet promptly to determine the appropriate educational placement. That the IEP team has to do that. Now, if a child goes to a residential placement where they have an on-ground special education school and the child has never been in special education before, that child should not be forced, shouldn't be attending that school at all. It's completely inappropriate for that child.
Okay, moving to a new topic, everybody's favorite, educational decision makers. And this is one of the key changes to the rules from 2011. They allow for the court to appoint an educational decision maker for the child. So we're going to talk about when and why you would do that. It's crucially important that all children, especially those who are in the dependency or delinquency systems, have an adult who is actively engaged in making education decisions and legally authorized to make education decisions on their behalf. This is because education is really driven by the parent or someone who is serving in the role as a parent. As for under special education law, the person who's considered the parent is absolutely the one who drives the process and the person who is able to initiate meetings and dispute the school's decisions. School discipline requires having a parent be involved, and just to make sure that the child does not fall through the cracks and it does not fall victim to the horrible statistics Maura cited for you at the beginning of the presentation, it's especially important to have some adult who's making sure that the child's educational needs are being met. So the court should be asking, and the GAL should be raising, the issue of whether the youth has an adult who is actively engaged in this process. If it comes out either through a direct question on this or in doing the other inquiries related to education, that there really isn't anyone, the court needs to think about whether they should appoint someone as the EDM, and if so, who, and then what issues that EDM needs to address. Again, the juvenile court rules specifically prescribe the process for this. In dependency, it's Rule 1147. And this can occur upon motion, but it can really occur at any time. The rules make that clear, as does the report incorporating, describing the new rules. And this happens either if the child has no guardian or the court makes a determination that's in the best interest of the child to limit the guardian's right to make educational decisions regarding the child's education. This is not something that should be taken lightly at all. These are important rights of the parent, and so there needs to be an opportunity for the parent to be heard and notice given to them before this huge step is taken. We do have a one-page document explaining the educational decision maker rules that you'll get tomorrow, as well as a model order appointing an EDM. We know that this is a confusing area of the law, and so we want to give you as many tools as we can on this. So again, the court should be appointing an EDM, or at least inquiring into it if there's no biological parent or other guardian who is involved in making these decisions for the child. And we do want to say that in some cases, the court order could actually recognize a person who is serving as an EDM rather than appointing an EDM. That's because, as I'm going to explain here, if the child has special education needs, the Individuals with Disabilities Education Act already prescribes who is considered a, quote, parent under the IDEA. And one of the people who can be a parent under the IDEA is the foster parent. This happens if there is a biological or adoptive parent who is not attempting to act on behalf of the child for special education purposes. So if the biological or adoptive parent is not involved in IEP meetings, not responding, and there is a foster parent who can serve in that role, they automatically become the IDEA parent. There does not need to be a court order that provides that for that to happen. They automatically become that person. However, the court order can recognize them as the EDM in case there's been any sort of confusion, just to make it clear to the school and everyone else involved that they're the ones who are the person who's serving that role. This is one of the reasons this is so confusing, is that there is another term, surrogate parent, that you see under special education law. The court can appoint a surrogate parent in the same way that they can appoint an educational decision maker. However, a surrogate parent, unlike an EDM, would make only special education decisions for the child. It's preferable in most cases to appoint just an EDM who can make all types of education decisions for the child and not limit that role to special education. For example, discipline or school stability, those are other types of issues that would come up that an EDM could address. And although the school also has the obligation under the IDEA to appoint a surrogate parent when a child, when a child does not have an educational decision maker or someone acting in that role, the school has to do that within 30 days of discovering the need. However, anyone the court appoints is going to trump all other potential decision makers. In the interest of time, we're going to skip this next poll. I do want to emphasize that a caseworker or child welfare professional, which would include a private provider caseworker or a parent or another caregiver in a group home or other congregate care setting, they are barred from serving as an EDM or a surrogate parent for a child with special education needs. The same goes for anyone currently employed by an agency providing for the education of the child. So the child's current teacher or a board member of the charter school a child attends, they are not able to be the EDM or surrogate parent for a child with special education needs. But who can be an EDM? A family member. There may be someone who the child unfortunately is not able to offer the child a living placement option, but is still involved in the child's life and has been stable in some way and could be a great option for being appointed as an educational decision maker. A family friend, a mentor, perhaps a former foster parent. In many counties, including Philadelphia, we now have court-appointed special advocates who are being trained and volunteering to serve as EDMs, doing a wonderful job. And in many places, the guardian ad litem also is being appointed to serve as the EDM. It's important for the agency and the youth themselves to be working with the court and the attorney to make sure that the person who is appointed to be an EDM is someone with whom the child has a close relationship. Ideally, it's someone the child has known for a long time and is going to be able to stay with them long term so that they have consistency with that. We have some sample findings for you to include in the court order. Again, this is important to protect parents' rights because this is something that they would otherwise retain the right to make those decisions, and we don't want them to be having that right taken away from them willy-nilly. It's important to go through the process here. A court order can specify as well that the EDM has access to all the education records, can specify the issues that the EDM addresses, and of course the EDM should always receive notice of further court proceedings because they need to be able to prepare for and attend and testify if necessary. I encourage you to look again at the 5 keys to implementing the juvenile court rules, which goes into this more specifically, but we are going to move on in the interest of time.
Okay, so just a few points on making progress. You know, we talk about whether the child is on track to graduate and what can be done about that. So In the context of asking the right questions in court and developing court orders, just wanted to highlight a few issues that come up. For example, there may be a child who is, excuse me, I'm sorry, I just flipped over 5 slides. Sorry about that. For example, the kinds of questions you want to ask. If a child is not making progress, if they're not on track, if they've repeated a grade, if they are still not making progress in the next grade, you want to be asking, should the child be evaluated for special education services? Is that an issue? Should there be an evaluation? And that will, of course, give you a lot more information about the child and to determine whether they might have a specific learning disability or whether they may have emotional disturbance to such an extent that it's interfering with their educational progress. In addition, disproportionately, children in the dependency system have developmental delays and also have disabilities more generally. So a 504 plan is a plan for accommodations for a child who may have a chronic condition. They may have diabetes, they may have asthma, which is very prevalent, or they may have a behavioral problem that really is interfering with their learning because the child is being disciplined out of the classroom very often. So to determine whether they need a 504 plan for accommodations. So to have caseworkers inquire into this. In addition, most schools have some kind of remediation. They're either a Title I school or they offer some kind of remedial help. So to say that we want to ensure that children are in a credit recovery program or receiving one-on-one tutoring, because a lot of schools do have that option in school. Or if the child is an English language learner, that there needs to be another assessment to determine if they should be receiving ESL, English as a second language. So to ask those questions and to have caseworkers inquire into these issues. And in that framework, I wanted to note that there may be instances where a child actually doesn't have anyone who is making decisions for them because they've just come into the dependency system. Maybe the parents are, their whereabouts are unknown, or there's an order, a protective order against them or whatever. So in those specific instances where there's no one else who can initiate the special education evaluation process, the IDEA allows for a caseworker to serve in that role if the court orders it. So a judge can appoint a caseworker or another child welfare professional to initiate that special education process. So you don't need for an education decision maker to be appointed, but rather to have a caseworker kind of jumpstart that process. So that's a very important legal entitlement under the IDEA.
And we included in your materials a sample order appointing someone to initiate that special education evaluation.
Right. And in addition, with respect to ensuring that a child's making progress and has needed interventions, we have for you some sample findings here and also a sample order language that talks through, and you'll find this in the Juvenile Court Rules as well, that talks through the kinds of interventions we can be thinking about integrating into court orders. So we hope that that is helpful. We're going to go on to graduation and transition planning.
And I just want to say at the start of this section that Juvenile Law Center has just put out a very comprehensive guide authored by Supervising Attorney Jenny Kempner with input from many experienced and knowledgeable people about transition planning for youth with disabilities. So that is something that you should definitely check out if you're working with youth who are of transition age. And Juvenile Law Center will also be hosting a series of webinars on transition issues over the course of the next year, and in fact did one last week, which is available if you want to get caught up on that. So we're just going to briefly touch on that here, but stay tuned for much more in-depth transition planning issues coming in this year. In court, the types of questions that can be raised regarding graduation and transition, you want to make sure that the child is making progress towards graduation. Unfortunately, we hear over and again from youth that we work with that they are 18 years old, but they only have a few credits towards graduation. This is one of the main reasons why we emphasize the importance of school stability and of youth going to the local public school, because we want to make sure that they are earning credits that are going to count towards graduation and that their education isn't being disrupted in the middle of the year so they miss out and get even farther behind. Do they need the credit recovery program, as Maura just mentioned, or other services in order to graduate? We're going to talk in just a moment about the possibility of getting a credit waiver of state requirements due to extenuating circumstances. That may be something that makes all the difference in the world for some of these youth. That's something the court can be inquiring into. And whether the agency has identified services that can support the youth's transition to independent living. Also, another rule that under the juvenile court rules that we need to be thinking about is the right to have a transition plan in place before the court discharges the youth from care. And that actually comes from federal law. It's also been embedded in our state law at 42 PA CSA 6352F 8.2. I apologize that we don't have that cite on the slide there. But that needs to be happening before the youth is discharged from court. This slide kind of reiterates those same issues. Is the child going to be able to graduate on time? And if not, what can we do about it? If so, who's going to issue the diploma? Sometimes these youth have bounced around so much that there's a question of whether their district they're currently in is going to issue the diploma, or whether their home district or a previous district will be the one to do so. That is something the court can help clear up. Again, here we have the rule that talks about the transition planning requirements. And this is something very important because the rule states that the court shall not discharge the youth without an acceptable plan. So in thinking about the child's plan for the future, education is a critical component under that. Is the child going to go on to post-secondary, or what other options does the child have to be able to successfully make the transition to independence and adulthood? We just also want to, of course, make sure everyone is aware of Act 91 and the expanded criteria for remaining in care or coming back into care, which includes youth who are completing secondary education or an equivalent credential, including a GED. It includes youth who are enrolled in an institution which provides post-secondary or vocational education, as well as youth who are participating in a program actively designed to promote or remove barriers to employment. And we, of course, have seen that youth who do remain in care up until age 21 have much better outcomes than youth who are aging out at an earlier age. So we want to just make sure that everyone's aware of the credit rules. We do have a regulation that states that all credits earned in a public school must be accepted by another public school. So as the court is inquiring into this child's education at all of those hearings that we've been talking about, they need to look at what school the child attends and make sure that if they're changing schools, that the agency has gotten the transcripts from the previous school and that someone is ensuring the child is getting full credit for all of the courses that they have taken in a previous school. Now just to touch on that waiver issue I talked about earlier, this is a great and underutilized tool. Basically, if a child in a school district does not have enough credits to graduate, the chief school administrator, which is usually the superintendent, can send a letter to the Secretary of Elementary and Secondary Education, who is currently Carolyn Dumaresque, explaining that the child didn't meet the credit requirements, but asking for a waiver of that requirement. And one of the acceptable reasons for getting a waiver is frequent transfers in school, which we know, unfortunately, these youth are often experiencing. So waivers should be granted under that regulation based on receipt of written request and for good cause shown. So this could be a tool that can, for example, a youth, they never completed their language requirement, or they don't have enough credits because of all their changes, but they are in 12th grade and otherwise capable of graduating. This can be something that helps keep them on track despite the technicalities that have occurred when they've changed districts. We want to also just make sure everyone is aware of a bunch of resources. I won't go into these in great detail here, but these are resources that can support youth moving on to higher education. the court should be making sure that the agency is looking into which of these can best serve the youth and make sure that they make their transition successfully. And this is just a slide to remind you of some of the things that we know could be in place and we know do work to help support youth in making that transition. The transition plan needs to be detailed. You really just can't say the youth applies to college and leave it at that. What kinds of accommodations do they need to be successful? What kinds of remedial services do they need before they get there? Are there mentor programs in the school? Where are they going to live on their breaks? All of these questions need to be addressed to ensure that the child is able to apply to, start, and finish a post-secondary education. See, we're near the end of our presentation here. Thank you for bearing with us this long. We did want to include the websites for our organizations as well as the Disability Rights Network of Pennsylvania, the helplines for all three of our organizations. Education Law Center and Juvenile Law Center, along with the ABA Center on Children and the Law, are also a part of a national organization called the Legal Center for Foster Care and Education. The website is there for that organization, and we have a host of different types of tools that you can use and keep updated on changes in the law and good practice related to education for youth who are in the child welfare system. Just another plug, if you haven't already filled out our survey related to foster care and education issues in your county, we do want to know what changes have been made to promote educational stability and success for children in care, what barriers remain, and whether the Legal Center, which I just talked about, has been helpful at all. We would greatly appreciate your filling out this survey by next Monday. And I think we have time for, I'll leave up the poll there if you want to get on there. That poll link will also be in tomorrow's email if for some reason you can't get on right now. And I think we have time maybe for one question.
Yeah, and before I get to that, I just wanted to mention that I think that Kate and I just want to emphasize that these interventions really do make a difference. I know we get a lot of emails from child advocates as well as judges and caseworkers who say that this has really made a difference in terms of the trajectory of children and intervening. We have kids who have needed accommodations plans in school, kids who have needed to be evaluated for special ed that haven't been. You know, the national average, between 13 and 16% of kids are eligible for special education, but that number jumps up to between 30 and 40% for kids in the dependency system. So that's a critical need and intervention. And we just have a lot more graduation and transition planning going on and starting it earlier. You know, the IDEA says this transition planning has to start at age 14. And I think that that's really critical that we start thinking in that way. We think that way in terms of our own kids and trying to plan for, you know, what will they do when they get out of high school, and these kids need even more support. So we do have one question here. A child moved into a new school district. The child has an IEP, but the school district put the child on 2 hours a day of homebound instruction until they complete the new evaluation. And the question is this appropriate? And under the IDEA, this would not be appropriate at all. A child who has an IEP, that's essentially the contract, and if they enter a new school district, that school district must comply with all of the provisions and provide comparable services to that child pursuant to their IEP. So the new school district should be educating that child in accordance with their governing IEP, even though they're doing a new evaluation. And that is certainly not grounds to have them on only 2 hours of homebound instruction. And in fact, there's the argument that they're being discriminated against on the basis of their disability in violation of both the IDEA and Section 504 of the Rehabilitation Act. So that's a huge problem. Another question, if a parent is court ordered, not to have contact with the child, do they still maintain special education decision-making rights? And that's an excellent question. The IDEA does not expressly address that issue of what happens. I have had instances where I've seen it actually go both ways. I've had parents who have a no contact order who are then prohibited from serving as the special education decision maker or from attending and participating in those IEP meetings, and therefore an education decision maker has been appointed for the child. And that's generally what has occurred. There has been a discussion, I know, in another case that the parent could participate via Skype or participate in another way without having physical contact. That seemed to undermine the emotional and traumatic stress that would be caused to the child. So that's an excellent question. So in general, we need to think about whether an education decision maker should be appointed for that child. And actually, notably, a school district would not be obligated to appoint a surrogate parent for that child. That could only be handled through a court order.
We have one final quick question. Where in the Pennsylvania Code is the information about the credit waiver that I discussed? That's at 22 PA Code 4.24I. And that's in the slide as well, if you didn't get to write that down. I will also say that although we unfortunately need to finish up today's webinar, we're past our time, you should feel free to email me, Kate Burdick, or Maura McInerney, my colleague here, at any point in the future with really any question that you have that comes up. We are happy to help, and we hope that you found today's presentation useful. Thank you to Megan and to Hallam Roth, also from Education Law Center, for helping us out, and thank you all for listening in and for all you do for kids in care.
Thank you.
Happy holidays and New Year.